The next case that the court is hearing today is Tavenner versus Pittsfield Township Board of Trustees et al. It is case number 22CA011831. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. I'll be keeping track of time, so let me know before you start how much time you would like to use or reserve for rebuttal. As you can see, your panel is Judge Callahan, Judge Carr, and myself. Please keep your voice up as these arguments are recorded and posted on the court's YouTube channel. And I can assure you that Judge Carr, Judge Callahan, and I have read the briefs. So we are awaiting to hear argument on this case. Appellant is represented by Attorney Rolfe. Do you want to reserve some time, sir?
Yes, I do. Could I reserve 4 minutes of time?
4 minutes. Now, I may interrupt you and let you know as you get close to that, and you can make a decision at that time whether or not to proceed or reserve the remaining balance. All right, go ahead, Attorney Rolfe.
All right, thank you very much, judges. This matter is regarding a ditch petition, and it's being opposed by my client, Mr. Tavenner, the appellant in this matter. And he has filed a action for injunctive relief based around jurisdictional issues related to this ditch petition. The ditch petition originated in 2017, 2018, and has now been filed 4 times. The third filing of the ditch petition is the one that this case arose out of. And Mr. Tavenner challenged the filing of that ditch petition for, among other reasons, that it had already been filed and terminated twice before. And furthermore, that there were problems with that petition. Mr. Tavenner argued that the county, Lorain County and Pittsfield Township had not abided by the statutory requirements under 6131, which is the ditch petition statute, and argued that they should be enjoined from proceeding with that ditch petition based on those jurisdictional and compliance issues. In the course of this case, yes.
I have to ask you a question, because in reading your brief and in just hearing so far just this part of the argument, you've mentioned jurisdictional issues, and we hear and read that word jurisdiction a lot, and there's a lot of different kinds of jurisdiction. Could you be more specific as to what the argument below was in terms of jurisdiction or lack thereof? Was that laid out? I realize you didn't have a hearing below, but was it laid out in the complaint for injunctive relief?
So we did lay it out, and that was on, I think, page 8 of our complaint and paragraph 34 with the succeeding paragraphs, where we talked about the lack of jurisdiction for the petition by the county. And the jurisdictional language, to me, comes out of an old case called Rambarger versus Carl. And that case talks about how the statute relating to ditch petitions grants counties or townships first they have a quasi-jurisdictional authority over projects when they're considering the petition, and then when they grant that, they have the full jurisdiction over the projects in order to take it to completion. There were cases that followed that. I think Municipi Creek was the case that followed that. And they're talking, these cases deal with situations where petitions are filed before the county commissioners or the township trustees, and then for whatever reason they're terminated. And the courts in those cases talking about whether they have jurisdiction to reconsider those matters later. And so that's the context in which we're talking about jurisdictional issues, and that's the case history for those topics.
And counsel, did those cases predate or post-date revised code 6131?
Well, as you know, the revised code has been reorganized a number of times, and this is actually a pretty persistent set of statutes here. There have been changes. It's remained very similar all through the years. The most recent revision was in 2001. I think it was effective March 24th, 2001. And so there were some changes to the statute, but what we're arguing here today, I don't see those changes having, getting rid of that case law. I think it is still good. The reality is that these statutes were enacted in the mid to late 1800s. And so the majority of case laws before 1950 on these. There's some later, but the courts were really wrestling with these issues in the first 70 or so years after they were enacted.
Thank you.
So I understand you're alleging that it is subject matter jurisdiction. The court did not even have jurisdiction.
That's correct. And so one of the things that makes this statute a little bit unique, as you all know, with special statutory remedies or special statutory proceedings, there is parties have to adhere very strictly to what that statute provides. So when it pulls you out of, say, a court of general jurisdiction and sets out its own procedure, you have to abide very strictly with that. One of the issues with the 6131 ditch petition statute is if a party doesn't like how that ditch petition is heard or handled at the lower level, they can appeal. But the Court of Common Pleas or the Court of Appeals can only consider 6 questions that are related to the ditch petition and their the merits of that project. So a Court of Appeals can consider, is the improvement necessary? Is it conducive to public welfare? Is the cost of the improvement greater than the benefits? Is the route or termini the best method to accomplish this? Are the assessments levied? Is the award for damages just? But in this, if there's some sort of procedural error or some sort of jurisdictional issue, that can't be considered by the court. And so,
I'm sorry to interrupt you, but on that issue then, how can the court consider those 6 factors if the petition no longer exists? I mean, I guess that's the crux of your appeal in this case, or at least the crux of Appellee's argument. The petition was withdrawn, correct?
The petition's been withdrawn 3 times.
Okay. And we're only focusing on the 3rd one because this case was the 3rd one. I understand it's been refiled, but how could the court consider any of those 6 factors?
Well, we're asking the court to consider other factors other than those 6 factors. This case was appealed both to the Court of Common Pleas and this court through the ditch petition process. It was under 613125. And the court in that case said, hey, because you're up here on a ditch petition appeal, we can't actually consider the jurisdictional issues that you are questioning. We then filed, that was why we filed our motion for injunctive relief. I believe the court can consider the jurisdictional questions. When the appellees opposed our initial complaint down at the trial court level, they alluded to the fact that this petition could be refiled. And one of the bases of us seeking injunctive relief is the fact that this has been filed a number of times. And we don't think that that's permitted under the statute. Because it can come back, because it has come back, it's come back now. And that new petition is before you on the record. And you can see for yourselves that it is substantively the same project. I think you can see the copies of the map slightly degrading it every time. We felt it was important to proceed with that. And given the fact that this has been filed and dismissed so many times, we think that alone is a good enough argument that it shouldn't be coming back. When parties don't like what happens, they have a right to appeal the ditch petition dismissal from the commissioners. And my client has been the only one who's been here and has, appealed that. Nobody else has appealed any of the dismissals.
And
So
on that issue, is there something in the statute or in case law that limits the number of times that it can be filed? A petition can be filed.
Well, this is actually a unique case. It does not appear that that has happened a number of times. There's a case, I believe, Crookshank, where is one of the very few cases that deals with two petitions of the same issue. And you had a case where a petition was filed and then a party sought an injunction. The court was considering that injunction and the petition was refiled. Now, in that case, because everything was happening at the same time, the court consolidated them into one matter. I honestly can't tell you that I've seen case law regarding filing it over and over again. The statute itself says that when a petition is filed and the court issues, or the commissioners or the court issues a decision on it, then parties who have an interest in that improvement can appeal it, and they have a certain amount of time. Now, it used to be 21 days. I think the current revision places that at 30 days. But the strong implication is that that's your opportunity. You don't get another bite at the apple from refiling the petition. And I think that's consistent with the court's reasoning in Rambarger and Municipi, where they're like, hey, if you've made a decision on this petition, you can't come back and either fix that decision, or you can't come back and have another bite at the apple. Those courts recognize that it is a little bit harsher than what a typical case might be, but they recognize that that's what the statute puts forth. And again, I don't see where any of the recent changes have adjusted that or impact that at all.
Let me just ask you, maybe I'm missing something. So I think I understood your Callahan's question to be, there's nothing in the statute that prevents it, and there's nothing that you're aware of in case law that prevents it. But I guess my question is, from a practical point of view, if the person is wanting a certain ditch or wanting certain procedures to be done, it would behoove them to go forward with it. If they just keep filing it over and over again, they don't get the relief they want, do they?
Attorney Rolfe, before you answer that question, you are at 4 minutes and 23 seconds. So take however much time you'd like. We'll be going into your rebuttal perhaps. Thank you.
Sure. So if I understand the question correctly, I don't think we're saying that we think that it can be filed. I don't think it can be refiled. I think that this statute really foresees individuals who are not part of the government making the petition. And what we have here is the Lorain County Commissioners contracting with another organization, the Pittsfield Township Trustees, who are then going out and finding other individuals to then petition themselves. And so I don't think that's allowed under the statute at all.
Thank you.
You are at 3 minutes and 47 seconds.
Okay.
Would you like to reserve that?
Yes.
All right. Thank you. Attorney Peltz, 15 minutes.
Thank you, and good morning, judges and Attorney Rolfe. Good morning. My name is Greg Peltz. I'm an assistant prosecuting attorney with the Lorain County Prosecutor's Office, representing the defendant appellee's Pittsfield Township Board of Trustees, as well as defendant appellee Board of Lorain County Commissioners. Defendant appellees request that this panel dismiss appellant's appeal as moot. The reasons that the appeal before this court is moot is two reasons. They're separate and apart from each other, but they also are a bit intertwined. The appeal is moot first and foremost because the underlying ditch petition complained of in Tavenner's injunction has been withdrawn, and that withdrawal has been accepted by the commissioners. So that petition obviously no longer presently exists. It doesn't exist before this court. It didn't exist before the trial court once the trial court ruled and dismissed Tavenner's injunction. Secondarily, the arguments.
Can I ask you a question on your first issue as to mootness? But the trial court made a decision, correct?
Correct.
Isn't that decision subject to appeal?
Correct.
So how do we have mootness?
We have mootness because the subject of the appeal is an underlying ditch petition that no longer exists.
Okay. Go ahead to your second reason then.
And secondarily, it's moot because the reasons in support of the injunction all pertained to that ditch petition that was filed in August of 2021. So it's moot on those both grounds because the petition no longer exists, and any argument in the injunction all relates back to a ditch petition and what Tavenner has self-styled as jurisdictional issues. And those arguments no longer exist either because the ditch petition no longer exists. So again, I believe those are two intertwined, more separate issues. But under either standard or either argument, defendant appellees would request that this court dismiss the appeal as moot. And then now moving forward to the actual arguments presented by Tavenner, both in his injunction and before this court. His injunction is basically seeking a declaratory judgment or an advisory opinion. And once the petition was withdrawn in the trial court, his injunction was moot. So by asking the court for relief from that underlying ditch petition, Tavenner was asking the trial court for a declaratory judgment or an advisory opinion. And, you know, his arguments relate to what basically can be described as an abusive process or an alleged abusive process by Tavenner, that all parties involved, the Lorain County Commissioners, the petitioners, the Stormwater District, the Township Trustees, have somehow abused the process. That hasn't really been articulated by Tavenner in his injunction, and it hasn't been articulated yet to this day what the abusive process necessarily is. I imagine it's just the filing of the ditch petition in August 2021, which, as it relates to this larger flooding project, was the third petition. But again, to address the panel's questions about are multiple filings permitted under the statute, they are because the statute has never said that you get one shot at filing a petition to alleviate drainage facility or drainage improvements. It just simply doesn't say that. And I know Tavenner wants that to be true, but it's just not true. And Tavenner hasn't even cited to where within 6131 or any of the other provisions within the revised code where a petition is only able to be filed once. And again, it just relates back to Tavenner's arguments that this is a general abusive process, but he's challenging the filing of the petition. He's not.
Wouldn't excuse me for interrupting, but wouldn't it eventually, if there's rulings from the court, you can't keep, usually just under general jurisprudence, you can't keep filing stuff because there's issues of collateral estoppel or res judicata, you know, those type of things.
I don't believe that's true, and I don't believe that's contemplated by the statute. I can think of a very likely scenario where a ditch petition just hypothetically was withdrawn for purposes of maybe the engineers completed a preliminary report and said, you know what, it doesn't really need to be done. And then there's an incredibly heavy rainfall or something else happens, and that ditch improvement does in fact need to go forward. And that could happen 6 days, 6 weeks, 6 months into the future. Under Tavenner's logic, if that were to happen.
Counsel, I'm sorry. My whole point is that there was a court ruling.
There was a court ruling?
No, I'm in my hypothetical, I'm saying, I'm sorry, I'm confusing you. In my hypothetical, I'm saying if there's a court ruling on whatever it is, be it a ditch petition or whatever, eventually that order is final and it's subject to collateral estoppel and res judicata is what I'm saying. So that I'm trying to differentiate as to when you can keep filing. You can't keep filing forever if there's been a ruling.
Correct. And I think that if there was a ruling on the merits of the petition.
That's what I'm getting at, yes.
Yeah, I think that would be a strong argument. I think that circumstantially you could make an argument to the contrary. Especially in my hypothetical, if there was severe flooding and the ditch was severely damaged and needed to be improved. There could always be new facts subsequent.
But wouldn't that be a new petition based on new circumstances, and it wouldn't be just refiling the same petition?
Correct.
Thank you.
Counsel, can I ask you a question? There was a lot of back and forth in the briefs about standard of review. The defense here filed a motion to dismiss. Is it a 12B1, a 12B6, a 12B3, 4? Oh, I mean, how was the trial court supposed to look at that in your estimation?
Well, and that's what I touched upon in my brief, is that I don't even think the court reached that analysis. I think it just, in my opinion, the trial court just conducted a very preliminary threshold jurisdictional analysis. And by the plain language of the trial court's judgment entry, it did not rule on the party's motion. The defendant's motion could probably be classified as a 12B6 motion. But the court, in my opinion, conducted a preliminary jurisdictional threshold analysis and said that this is moot. The underlying ditch petition has been dismissed and this matter is moot.
Thank you.
And that, that has to do with obviously Tavenner. And then in accordance with the standard of review, I also think it's unclear what the standard of review may be for this panel, for this court. Again, once the ditch petition was withdrawn, I think that Tavenner's complaint for an injunction transitions almost into a declaratory judgment or a advisory opinion, asking the court determine that no ditch petition can ever be filed again pursuant to the existing ditch. And I think under that under that scenario, this court's standard of review would be an abuse of discretion. If it's just a general mootness, then that would be de novo. But again, I think that's unclear because the relief that Tavenner requested in the trial court is kind of twofold. It's issue an injunction because they filed, because the petitioners filed a ditch petition, but also issue a ruling that they're barred from forever doing this. And that would be a declaratory judgment or an advisory opinion, in my opinion. And then moving on and addressing Tavenner's individual assignments of error, as I just touched upon briefly, I think the trial court, it didn't consider his complaint. So it didn't consider his complaint under the wrong view or the right standard of review. It conducted a threshold jurisdictional analysis. And then I think Tavenner's second, his third, and his fourth assignments of error take issue with what I would describe as dicta by the trial court. In Tavenner's second assignment of error, he states that the trial court cited to the wrong legal doctrine. The trial court generally cited to the mootness doctrine and provided a definition of that. In his third assignment of error, I also think that's dicta. The fact that Tavenner has self-styled that there are jurisdictional issues. I don't even know what jurisdictional issues there are. And in Tavenner's injunction, he claimed a lack of jurisdiction based upon the petition not being filed by the property owner. That's not true. I mean, that's just an allegation. He hasn't asserted that that was true or not. That the petition was dismissed, so that jurisdiction is somehow dismissed. There's no statute under 6131 relating to that, and that the petition was somehow filed by the straw man of the stormwater district. He classifies these as jurisdictional issues, but I don't believe they are jurisdictional issues. I believe he's just taking issue with the procedure in which this petition was filed. To me, a jurisdictional argument under 6131 would be the petition was mistakenly filed in trial court or in the trial court, or mistakenly filed in the probate court or the board of revision or any wrong entity. And at that point, none of those entities, none of those bodies would have jurisdiction over the ditch petition. It lies only with the Board of Commissioners. So just by simply styling it as a jurisdictional issue, I don't get there. I think that the jurisdictional process under 6131 contemplates a view, it contemplates a first hearing, and it contemplates a final hearing. And those are the jurisdictional issues. Tavenner has cited to what amounts to the clerk's duties, the clerk of the Board of Commissioners, and the engineer's duties under 6131, and somehow takes those duties and states that they are somehow jurisdictional issues. I don't see that. I see those as duties by the clerk and the engineer under the statute. But be that as it may, the trial court's mention of the jurisdictional issues in its judgment entry was just dicta. I don't think the trial court was mistaken in that regard in stating that. And then lastly, or moving on to his fourth, Tavenner has argued that in his fourth assignment of error that the trial court, again, erred when it noted it couldn't give Tavenner relief. Well, it couldn't give Tavenner relief because it found that the injunction was moot. But again, that's just dicta. It's just the trial court is just noting that it can't give Tavenner relief. I don't think that's a proper assignment of error. And then again, as I mentioned at the very forefront of my, at the very beginning of my my statements. I just think his fifth assignment of error, the mootness pertains to the underlying ditch petition. I don't think it extends anywhere else. If I may have one quick moment. And lastly, I did want to just state this for the board. I'm sorry, for the judges. You know, these ditch petition processes under 6131 are meant to alleviate drainage issues with the flow of surface water. And that's what they've been trying to do, is just assist in the flow of water. And that's all there is to it. You know, I think that, you know, this is a very protracted litigation, and, you know, the defendant appellees are sympathetic to Tavenner's beliefs as it relates to that protracted litigation, but they're just his beliefs, and they're nothing more. With that, if there's no further questions.
I guess my question is, it seems like maybe protracted because your client keeps withdrawing the petition.
Sure, I mean, that's fair, and there were reasons for that, good, bad, or indifferent. They were withdrawn. I think that the second petition was withdrawn because there were two new commissioners coming in, and it was determined based on that board to withdraw the petition and start anew with two new commissioners. So, you know, good, bad, or indifferent, that was a decision that board made. But there's no abuse of process with trying to file a petition to alleviate flooding of the subject property. And I think that's the biggest takeaway.
But I guess my question would be, and this is not necessarily, because this would go more to the merits, but it can't be that big of an issue of flooding if the county just keeps withdrawing the petitions. Because like you said, it's been very protracted.
That's a fair point, Your Honor. That's a fair point, but you know, the county does feel that it is an issue, and they are filing, and they're trying to file according to, as Attorney Rolfe had mentioned, the new requirements under 6131 that came forth on March 24th of 2021. And I believe, you know, I believe it may be as simple as that.
Attorney Callahan, or excuse me, Judge Callahan, any questions for the attorneys? Anything further, Judge Carr? All right, anything further, Attorney Peltz, before I turn it over to Attorney Rolfe for rebuttal?
No, nothing further. Thank you, Your Honor.
All right, thank you for your argument. And I've got 3 minutes and 47 seconds for your rebuttal, Attorney Rolfe. Go ahead.
Thank you, Your Honor. Just to address a couple of the issues, we believe that the standard of review under this case for this court is de novo, and we've listed that in our assignments of error in this case. You know, with regard to Attorney Peltz's claim that, you know, we're upset about where it's filed or things like that, the core of our argument is that the petitioner and the process in general has to abide by the statute. And so the Woodmansee line of cases, which includes Lowe, it talks about, you know, how you can appeal jurisdictional issues in this matter. But Lowe in particular talks about how when there's a failure of the government to meet the requirements under the statute, that's looked at very strictly. And so that's really the core of our argument. It's not so much a procedural, but under a special statutory proceeding like this, one that involves the government seeking to come onto someone's land and put an improvement on their property, and sometimes private land. Even though the statute doesn't provide for eminent domain or something like that, courts have ruled that it's extremely important for the government to abide by that statute strictly. And I would say that that's really the core of our argument here, that failure to meet the requirements of the statute. And we believe that's supported by case law. Yes.
You started off saying you believe it's a de novo review. Everybody wants a de novo review. Can you tell me why this is subject to a de novo review in your opinion?
I think it's subject to a de novo review because the errors that we are talking about with the underlying trial court are ones, number one, of a failure to apply the correct standard in reviewing the opposing party's motion to dismiss. And then also when they're talking about things like, we can't give you any kind of remedy, you have to proceed under 6131. Those are issues of statutory interpretation. And so based on the trial court's judgment entry, that's why we think this is a de novo review. And I would simply say with regard to the mootness relating to only the single petition, this court has the ability to consider extrinsic evidence outside of the record of that single petition in terms of determining whether this matter is moot. And so we think it's important for the court to consider the fact that the petition has been filed again and there are proceedings going forward. And again, the court has a petition before you. So I don't know that it's persuasive that the one petition has been dismissed when it's come back again. It's the zombie that just, never dies. So those are our points in rebuttal, and we'd like the court to reverse the decision of the trial court below. Thank you.
Any last questions, Judge Callahan or Judge Carr?
Thank you.
All right. Thank you both for excellent arguments on the case. We're going to take the matter under advisement and issue a decision in due course. The clerk of courts mails a copy of our decision to counsel on the day it's released. And as you probably know, they are also posted on the Supreme Court of Ohio's website. So on behalf of Judge Carr, Judge Callahan, we want to thank you for both of you did a very, very nice job arguing the case, and we'll take it under advisement. So have a great day.